Now, ladies and gentlemen, we are moving to the other one. It's by Mr. H.A.Menaka Harankaha from the Faculty of Law, Colombo University. This topic is promoting entrepreneurship and protecting copyright of authors, revisiting to the traditional means of originality and authorship of copyright. Thank you.
Thank you, sir. Ladies and gentlemen, please bear with me first, not using IT assistant in my presentation. I thought of getting a direct attraction to me rather than to look at the screen and it is something else. So as Dr. Sarnarajan correctly mentioned, that is the topic, promoting entrepreneurship and protecting copyright of authors, revisiting to the traditional meaning of originality and authorship of copyright. So I don't think this is a time to discuss everything that I have analyzed and discussed in my research paper. But for your convenience and I thought of summarizing some of the basic arguments that I have already made in my research paper. Basically, you know that even this session is dedicated for the topic which is called education and legal education and innovation. And also some of our speakers also very correctly discussed the importance of innovation. In the aspect of innovation, it is also when you discuss the IP, right, it is completely regarding the innovation itself. So when it comes to the copyright protection, I am discussing about the copyright protection. When it comes to copyright protection, even you can't neglect the importance of the copyright in the broader scenario of it is originality or the creativity. When you look at the early history of the copyright law, you see that basically copyright law is evolved and also based on the basic concept of the creative. If it is a creative work made by someone, maybe an author or any other kind of a creator, so that particular work is decided to be protected under copyright in order to give some credit, awards to the copyright owner or the author of the creator. So basically it was a creative work that was protected under copyright. But when you look at the present scenario of copyright law, you see it is not only protecting creative or the basically original work, but when you look at the businessmen, investors, entrepreneurs, and also the persons like as organizers of some events, you find the fact that all those persons are not inventors or the creators or the creative persons. But their rights also have been protected, protected under copyright. Why is that? It just means, can we argue that those organizers, just think of the producer of a film. Are we going to say the producer of a film should not be protected under copyright law because he is not a creative person? When it comes to the director of the film, you may sometimes say, yes, the director is a very creative person because of his creativity and because of his original contribution to be for this work. But what about the producer who basically invests his money for the particular work and made all the other organizational things with regard to the particular filmmaking? How can we protect his rights under copyright law, where the copyright law is basically, as we have argued, based on protecting the creative work if he is the producer is not a creator? But when you look at all the other things, just like suppose the producer of programs, sound recorders, and also some other employers who engage in some other copyright business, all those persons are normally considered as copyright owners, even though they have not contributed any creative things to the work. What I am going to tell now in my paper is, we cannot now regard all those things distinguished between the creativeness or the organizational skills as protecting skills of persons, their judgment, and not only that, but even their investment as well. I am repeating that word again and again, investment as well. If someone invests for some work, that also is the fact for the purpose of protecting under copyright law. So, but when it comes to our scenario, Sri Lankan copyright law, what I have to discuss is there are some loopholes and even some impediments as well as in protecting copyright. You see that in our system, we basically have a very strict division between some aspects of copyright. For example, you find we have copyright and neighboring rights. We have economic rights and moral rights. We sometimes protect the work because of its originality and sometimes neglect the non-original work. So these things like moral rights, economic rights, neighboring rights and copyright, because of the strict application of these things in deciding whether the particular person's work should be protected under copyright or neighboring rights, sometimes deprives the right of some innocent artists. So just think of some instances where we can find, especially in the wake of today's digital environment. Because of the cyberspace and the digital environment and network world today, sometimes it is hardly possible to say or see this is really an infringement of copyright. But in fact, you find infringement because of the impact of the technology. In case we are suppose the particular, just think of something like rapping. You know, rap. In musical industry, you find the kind of rapping going today. What is meant by rapping? Any other persons can sometimes use some other person's musical work, and by way of rapping it, he may sometimes produce a new version of the song. How can we identify or classify or interpret this kind of rapping of a musical work? So it is sometimes difficult to give some meaning to that, even in that scenario. Some use to say rapping is kind of a modification of the original song. Whereas some other also argue, no, it is not a modification or adaptation, it is a kind of distortion of the original work. So if it is a distortion of original work, so who has the right to go against that? Suppose just think of the singer who is not having the copyright protection but only having the neighboring right protection. In case where his song that he has already sung is now being rapped by a third party, which may sometimes affect his reputations and his goodwill as well. But this poor singer is not having the right to go against that because of his not a copyright fault. So there are many instances, even in the cases of where the film industry, as I discussed earlier, producer and author or the director, so the director has only the moral rights, whereas the copyright goes to the producer. But why not we try to say that even the author, who the producer, even the director, who has given more contribution to the work, to give some copyright protection. Because in other jurisdictions, you find that even UK, where you find that they have, even the director is having copyright protection. So therefore, what we need to do in our system is, I think, we need not to interpret, define these divisions or the aspects of the right, neighboring rights, copyright, and moral rights, and in a very strict manner, without doing that one, even the court can involve with interpreting and giving more justice to the innocent persons in case of protecting law. So you will be getting the no idea